You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to season 2 of Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien, and I'm joined by my co-host, Kyle Evans. This is episode 4, State of Texas versus Howard Paul Guidry. In part 3, we conclude our discussion of the November 9th, 1994 murder for hire of Farah Baquer Fratta, a mother of 3 gunned down in a garage in Humble, Harris County, Texas. In parts 1 and 2, we talked about the case against Farah's estranged husband, Robert Fratta, who was executed on January 10th, 2023, and middleman Joseph Andrew Prystash, who awaits execution on Texas death row. In part 3, we're talking about the role played by Howard Paul Guidry, an 18-year-old transplant from Vermilion Parish, Louisiana. We'll talk about the evidence against Guidry, his first conviction, which was reversed by a federal district court in 2003, his retrial, capital murder conviction and death sentence, direct appeal, and state and federal post-conviction claims. And good afternoon, Kyle. It is Good Friday.
Yeah, good afternoon, Lisa. How are you on this Good Friday?
Very well, thank you.
I think
We've
we're
had a couple
getting
weeks of
some kind of an Easter snap.
Yes, it's currently raining here, and it's expected to be very nasty over the next couple of days, even though we've had weeks of really beautiful weather.
Excellent.
So, all right, well, we'll get in our discussion of Howard Guidry. And of course, we'll start though with Farah Baquer Fratta, who was born August 5th, 1961 in Guildford Borough, Surrey, England. Her father was Lex Syed Baquer, who died in 2018. Her mother was Betty Baquer, who is still alive. She has a brother, Zane. She was a ticket agent for American Airlines in Houston, Texas. She married Robert Allen Fratta on May 7th, 1983, and filed for divorce from him in March of 1992. She had 3 children, Bradley, born in 1986, Daniel, born in 1988, and Amber, born in 1990. And of course, she was killed with 2 gunshot wounds to her head. In this episode, we're talking about the trigger man, Howard Paul Guidry. He was born April 15th, 1976 in Abbeville, Louisiana, which is in Vermilion Parish. It's out around Lafayette in West Louisiana or Southwest Louisiana. His father was Alvin Guidry. I believe he was born around 1946 and he died around 2005. I haven't been able to confirm the exact dates or the correct years. His mother is Joyce Guidry, and she was born in 1947. She's still alive. He has a sister, Denise, born in 1967. He finished the 11th grade or left school in the 11th grade and got a GED. He did have a history of pretty severe asthma as a child, and he did have a lot of treatment and hospitalizations and limitations to his ability to do things and go places due to the asthma condition. Also, Southwest Louisiana weather probably was not made things more difficult, especially during the spring and summer months.
Yeah, absolutely.
And into the fall, because we don't really have fall, except maybe a couple of 3 days sometime in November. He also allegedly suffered headaches, either as a result of medications or the asthmatic condition. His emotional, mental diagnoses, he did suffer depression, cognitive impairments, ADHD, and he began using drugs, including selling crack by the age of 13. And his drug of choice was called Fry, which is marijuana laced with formaldehyde, which is
That's
used
some
or was at
scary
one
stuff.
time used to preserve dead bodies. So that does not sound like a good idea.
No, that's some scary stuff.
And of course, his criminal record includes dealing crack since the age of 13, auto burglary, possession of a weapon, armed robbery, and assault on a public servant, which occurred, I believe, while he was awaiting trial on capital murder.
Okay, is that a policeman, I assume?
Either a policeman or a correctional officer.
Oh, yeah, that makes sense. Probably a prison guard. Yeah, that makes
Yeah.
the most sense.
And I think that was while he was in the Harris County Jail awaiting trial. And of course, the victim was Farah Baquer Fratta. Again, we have the crime occurred on Forest Fern in Humble, Texas. That was the home where Farah Fratta lived with her 3 children. It was in Harris County. Howard Guidry agreed to act as a hitman for Robert Fratta in exchange for $1,000 to finance the purchase of cocaine to sell. Guidry told the defense expert that his priority had always been money, no matter how he got it. Guidry also had a history of armed robbery and auto burglary and admitted to selling crack as early as age 13. One of Guidry's drugs of choice was Fry, which is marijuana laced with formaldehyde. On November 9, 1994, Guidry dressed in black and met up with his neighbor Joseph Prystash at their apartment complex. Between 4:30 p.m. and 5 p.m., they left the complex and drove to Humble, stopping on the way to purchase some pot. Prystash drove Guidry to Humble, where their first stop was a grocery store parking lot. After ensuring that Prystash's borrowed cell phone and the pay phones in the parking lot were working, he dropped Guidry off at Farah's house. Guidry climbed a fence and waited in the children's playhouse in the backyard. When Farah hadn't arrived home as expected in the early evening, Guidry, using the cell phone, contacted Prystash, who was waiting in the grocery store parking lot at the payphones. Prystash instructed Guidry to wait. And as we know from Fratta and Prystash, they had also been in communication during this time.
Mm-hmm.
Farah arrived home a few minutes after Guidry's call. As she backed her car into the garage, Guidry entered through a side door. As Farah got out of the car, Guidry shot her once in the head. Across the street, Farah's neighbors, Laura and Darren Holscher, heard the gunshot and a scream. Laura watched as Farah fell to the floor of the garage. She heard a second shot and watched as a short black male walked out of the garage. She described the man to police, including that he had a large head. And if you look at photos of Guidry, I'm going to say that's a pretty large head. The black male hid in the bushes briefly, then a silver car drove up and he got in the passenger side. The Holschers observed the vehicle was silver and had a headlight out. Guidry returned the gun used to kill Farah to Prystash. Fratta was picked up later that night and Guidry's $1,000 payment was seized by police. When police identified Mary Gibb through Fratta's address book and phone records, Prystash returned the pistol to Guidry with instructions to dispose of it because Prystash was worried about a search of Gibb's apartment. Instead, angry that Fratta hadn't paid for the hit, Guidry kept the gun. On March 1st, 1995, Guidry was arrested fleeing after a bank robbery, and the weapon was seized by police along with 2 others. The investigation of Farah's murder had also reached the grand jury phase by this time. Gibb, facing a grand jury subpoena and potential tampering with evidence charges, decided to come clean. On March 4th, 1995, Gibb gave a statement to police that connected the dots, implicating Fratta, Prystash, and leading police to Guidry, who was in custody facing bank robbery charges. When
He was not kidding. He will do anything for a buck, won't he?
Yeah. And he was involved with a gang. And one of the things that is incomprehensible to me is that his family was not, his father was a truck driver. His father and mother both worked very hard. His sister Denise had married a man. He was living with her and her husband. He was working with her. She worked, and she worked very hard for everything that she had. So this is some flaw in his personality or his character, because he was not raised by criminals. I mean, even his grandparents, his cousins, they're all
good family,
upstanding members of the communities, good people, hardworking people.
Well, the
They're
poor
not
kid just,
criminals.
probably just got involved with some bad guys. And I mean, if you're doing the formaldehyde and pot at 13, it's gonna mess up your brain.
But I still think there's a flaw in the character, because I mean, I didn't hang around perfect angels all my life, but I knew the difference between right and wrong. And when the people I was hanging with were doing wrong, I separated myself from those people. I didn't go along with them. And I didn't care if they didn't like me anymore. I mean, I had friends that became, were no longer my friends.
Yeah, it's a shame he didn't have that couldn't walk away. Yep.
That strength of
definitely, character. There's definitely something going on. I mean, it sounds obvious, but I mean, to be in that bad of a shape at 13, or probably earlier than 13. I guess 13 was when he got caught, right?
I don't know that he ever got caught selling drugs.
Oh,
because
okay. Maybe
his
he just
family
said he was
has
doing
denied
it
that he ever sold drugs. They've also tried to deny the times that he was caught, and the times that he pled guilty, and the times that he was in, youth services. But which there's not a whole lot of information that I could verify. So I kind of, there's a general idea that he was getting in trouble in his mid-teens, and his family was a little perplexed. But now that he's on death row, his family says, oh no, that was not him. It didn't happen. It never happened. The district attorney made all that stuff up.
Of course.
So, but anyway, so back to the summary of the case. When police checked the serial number of the 38 seized from Guidry, it led back to Fratta, who'd purchased the pistol around 1981. While ballistics examination couldn't conclusively link the gun to Farah's murder, it was found to be consistent with the bullet recovered from the garage and with the type of weapon that could have fired the bullets that killed Farah. Initially, Guidry declined to make any statements to investigators. After investigators told him that the attorney appointed to represent him on the bank robbery case had authorized him to talk to detectives, he made a statement. In his first written statement, Guidry claimed that he was the getaway driver and pointed the finger at Prystash as the triggerman. In his second written statement, he made a full confession, admitting that he pulled the trigger and killed Farah in exchange for $1,000. He would later make the same admissions to a defense expert who was evaluating him and his drug use in preparation for trial.
That's another one of these examples, you know, the people that always say every confession was forced and false because it wasn't perfect the first time. I mean, this is a great example of what's seen over and over again, where people will confess maybe to be in proximity or participate, but not have done the worst thing, thinking that that'll get them off. And then eventually they ultimately, you know, fully
Right.
confess, but
Right.
it's usually never everything the first time. It's usually a couple of different turns before they
And
fully admit everything.
yeah, correct. And you know, I'm gonna go out there. In all probability, the detectives did trick Guidry into making a statement by telling him, because he was asking for an attorney, by telling him that his armed robbery attorney had said he could talk to them, even though they never talked to that attorney and never, got his permission to talk to Guidry. However, it also may be that Guidry misunderstood what detectives were telling him. And I think what really resulted in his conviction being ultimately reversed is that by the time the detectives testified in federal court, their stories were not matching up.
Mm.
And that led to the judge believing that they were not credible.
Yeah. Well, that's problematic, right? I mean, it's
So,
one thing for cops to fudge on, hey, we've got some evidence against you, but yeah,
mhm.
fudging on, hey, your attorney said it, basically denying you the right of counsel's
Yeah.
pretty
And they,
problematic.
they denied to the federal court that he asked for an attorney, whereas they had testified in a state hearing on a motion to suppress the confession. And their testimony was slightly different. Now, the passage of time, their testimony may have been, I don't remember, but if that's what I testified to, that must be it. But that doesn't always, that all can lead to problems of credibility.
No,
So,
absolutely.
Guidry was arrested for Farah's murder on March 13th, 1995, and he was indicted on March 13th, 1995 for capital murder. That indictment was dismissed on August 23rd, 1996. He was re-indicted on August 15th, 1996 for capital murder. And while awaiting trial, he assaulted a jail officer. His trial was held in the 230th District Court, Harris County, Texas, before the Honorable Robert Burdett, who was assigned to come in from another district and conduct the trial of Guidry. Counsel for the state was Kelly Siegler and Casey O'Brien. I believe Casey is a gentleman, but I don't quote me on that. Guidry's counsel at the first trial were Alvin Nunnery and Loretta Johnson Muldrow. They did challenge the admissibility of his confession or his statements. The judge, even after hearing all the testimony, including testimony from Guidry, found that the statements were voluntary and that they were admissible. The guilt innocence phase of Guidry's trial was held February 17, 1997, and concluded on March 21st, 1997. The jury's verdict on March 21st was guilty of capital murder. The penalty phase started on March 24th, 1997, and concluded on March 26th, 1997. The jury answered yes to special issue number 1, future dangerousness, and no on the question of whether the mitigation evidence was sufficient to outweigh the aggravating factors. So the jury sentenced Guidry to death on March 26, 1997. And in Texas, that's a formal sentencing occurs the same day with an order signed by the judge. On May 22nd, 1997, the court did hold a motion for new trial hearing. I'm not quite sure what the grounds were because the records for the first trial are not imaged, and so I can't see what the motion for new trial was. That was obviously denied, even though I can't find the order or the actual date of
Yeah.
denial. And post-conviction, Guidry was involved in an attempted escape from death row with 6 other inmates. And that was in 1998.
He is definitely he's an interesting guy. He's assaulted a jailer and attempted to escape.
Yeah. And I'm not going to belabor it too much, but anyone interested on an absolutely ridiculous view of a later event, read the articles written by Gloria Ruback about Howard Guidry. We might talk about her a little bit later.
Sounds good.
Guidry's direct appeal went to the Court of Criminal Appeals because this was a death penalty case. If he had been sentenced to life in prison, it probably would have gone to the Intermediate Appellate Court for the Houston, Harris County part of Texas. But it went to the TCCA because it involved death. His attorney was Francis M. Northcutt. His notice of appeal was filed May 27, 1997. The issues being raised by Guidry on his initial direct appeal were first that the judge, Robert Burdett, had no authority to conduct the proceedings because his order of assignment began after the trial was in progress. And this was actually because of a mistake where an order of assignment for a different case was put into Guidry's record. That order of assignment was subsequently replaced.
What is that order of assignment? What does that mean specifically?
Basically, the order of assignment is the chief judge of over the court. And I think it's like districts in Texas. So it's not necessarily the chief judge of Harris County. It's a chief judge of the courts that encompass Harris County and Montgomery and, Liberty and the other counties in that regional. So I guess it's like a regional judge, maybe.
Got it. Okay.
And I'll do a little bit more research into that and on how the district courts are organized. And I'm making a note right now. And the next time we talk about a Texas case, we'll talk about orders of assignment and chief judges and all that stuff. So anyway, so that's like there's an incorrect assignment in the record, and they're using that as a basis, even though
that's not really
the correct assignment's brought in.
Yeah, what I was trying to get underneath, that's not really anything specifically related to his trial, more of just like a paperwork error. Is that fair?
More or less, yes. And really the time to raise that would have been prior to his trial beginning.
That's what I was thinking, right? Wouldn't that be something you do before? Because
you say, Your Honor, you don't have authority. This is the order of assignment, and it only lasts for, this many weeks, and we're 2 weeks beyond that point. You no longer have authority. And they've tried to raise that in Rodney Reed about Doug Shaver, which they were unsuccessful in doing. And then they tried to raise it when the chief judge appointed Judge Langley, rather than allowing the Bastrop judge to assume authority over the case. But let's not get off on a Rodney Reed tangent today. His second point of error was that the evidence was insufficient to support his conviction because there was no evidence of guilt presented after the effective date of the allegedly untimely assignment. He alleged ineffective assistance of counsel due to trial counsel's failure to object to remarks made by the trial judge during voir dire that allegedly authorized the jury to discriminate against appellant on account of his gender when deliberating on the mitigation special issue. The trial court, point 4 was the trial court's failure to specifically address in its finding of fact and conclusions of law concerning the voluntariness of appellant's confession, the certain conflicts in the evidence. Points 5 and 6 were kind of joined, and they were that the trial court erred in admitting Guidry's confessions on the grounds that his statements were taken in violation of his Fifth and Sixth Amendment rights to counsel because he was in custody for aggravated robbery when questioned by police about the instant capital offense, and was entitled under the Sixth Amendment to have his attorney in the robbery case present at his interrogation concerning the capital offense, and also his claims that he invoked his Fifth Amendment right to counsel during that interrogation. Points 7, 8, 9, and 10 were also joined. The points were that the trial court erred in excluding the testimony of 4 prospective witnesses, and that's Dewar, Gottlieb, Scott, and Yarborough. These are attorneys who were present in a hearing or in a judge's chambers during proceedings in Guidry's pretrial proceedings in Guidry's trial, who heard detectives make inconsistent statements about Guidry's questioning that were inconsistent with their testimony at the hearing on the voluntariness of Guidry's confession. They wanted to basically bring these people in to testify at trial to these inconsistent or allegedly inconsistent statements. He argued that their testimony was relevant and admissible for purposes of the jury's evaluation of both the credibility of investigating officers and ultimately the voluntariness of Guidry's confessions. The trial court's exclusion of the testimony violated Guidry's due process right to present a defense. Point 11 was that the trial court erred in denying the admission of Guidry's testimony from the suppression hearing under Texas Rule of Evidence 804B, which basically says if a witness is invoking his Fifth Amendment rights not to testify, a party proponent can bring in prior testimony as long as the other side had the opportunity to cross-examine that witness. However, if it's your testimony that you're trying to bring in, you cannot refuse to testify and invoke your Fifth Amendment right not to testify to bring in your prior testimony that then can't be cross-examined in the criminal trial. That's not how
Seems
it
to
works.
make sense.
So yeah,
Right.
you can't say, I'm unavailable and
Right.
bring your own testimony in. It's only if you have a witness who then won't testify or invokes their Fifth Amendment right, and they've given prior testimony that's helpful to your position. Point 12, the trial court erred in allowing the admission of State's Exhibit Number 1, an inventory from the Fratta divorce proceedings listing a Jeep CJ7 as an asset in Fratta's custody, which Guidry claims was inadmissible hearsay. And that's basically because the Jeep was allegedly the payment to Joseph Prystash, which is why it would be admitted Guidry's trial to corroborate, the murder for hire aspects of the case against Guidry. Points 13 and 14, the trial court erred in admitting the testimony of Mary Gipp, girlfriend of co-defendant Joseph Prystash. Gipp testified to statements made to her by Prystash about his and appellant's roles in the instant murder. Point 15, that was 13 and 14. Point 15, the trial court erred in overruling Guidry's hearsay objection to testimony by Detective Valero that Gipp's name and phone number were listed in the address book belonging to Fratta. Point 16, the trial court erred in overruling Guidry's objection to the admission of State's Exhibit Number 60, a firearm recovered by Deputy Moore from a backpack belonging to Guidry. Guidry argued that the identification of the exhibit was based on hearsay because Moore relied in part on a serial number recorded in an out-of-court report prepared by another officer. Points 17 and 18, the trial court erred in sustaining the state's hearsay objections to two questions posed by Deputy Billingsley on cross-examination. The state failed to provide, point 19, the state failed to provide Guidry with proper notice of certain extraneous offenses that offered against him in the punishment stage. Point 20 and 21, The prosecutor argued outside the record when he stated that a co-defendant in the case had received the death penalty, which was an improper jury argument, and the trial court erred in not entering a mistrial or granting Guidry's motion for new trial. And finally, points 22 and 23, the trial court's decision to permit the jury to continue deliberating after they twice indicated an inability to reach a unanimous verdict on special issue number 2, which is weighing the mitigating and aggravating factors in determining whether to sentence someone to death or not.
Hey, Lisa, I think we talked about this
Yes.
before, but are these like generally these appellate, are they doing this pro bono? Is it state funding, or is Guidry actually paying for his appeal? Is it provided?
Yeah, in this case, Guidry was indigent, and so his attorneys were appointed by the court, and they were paid by either the state of Texas or by Harris County.
Got it. Okay, so they are basically they're public appeals attorneys, I guess you could say, if you will.
And you can look at you can't necessarily Guidry's initial trial documents, but you can look at later trial dockets, and you can see attorneys' timesheets and applications for payment, because their payment is authorized by the trial court. I don't know what entity it's made by, and different states do it in different ways. Some states have an indigent defense program set up, and they receive money from the state in a budget, and they, use that to hire and pay attorneys. Then there are other states where they have probably private attorneys who can be appointed and then who are paid by the state. So that's, but I think in Texas, it's you make your application through the state court, and then the federal courts also have indigent defense budgeting available to pay attorneys in the federal habeas program when a case is on federal habeas and is being reviewed by federal habeas courts. It can be complicated, but and I've known a lot of public defenders, and they're not paid what they could make as a private attorney.
Yep.
On a case. They don't get retainers.
Right.
They get paid for their hours, and they generally don't get paid what like a private civil attorney could bill $150, $250, $300 an hour. And in some states and some jurisdictions, a partner at a law firm can bill clients $500 an hour.
Oh, yeah. Well, and I mean, it's a whole other podcast, but I mean, people aren't wrong when they say, I mean, our justice system, a big input of it is, how much money you have and how much you can afford on a really good attorney, which is, we can't, that's a whole other conversation and a very difficult problem to solve. But yeah, it's definitely doesn't mean that, everyone's innocent who doesn't have a good attorney, but it certainly makes life easier. Hashtag OJ.
I don't think criminal defense or indigent defense should ever mean that an indigent defense attorney gets a blank check.
Right. Yeah, that's fair.
And working in civil law, and I work for a firm, if we get like we take a deposition, if the invoice for the deposition that is needed for our case is over a certain amount of money, and sometimes clients set a realistic limit, and sometimes clients don't set a realistic limit. If it exceeds that limit, we have to send it to the client to pay. If we pay it and then we submit it on a bill, they refuse to pay it because we weren't supposed to pay it. And so we spend a lot of time arguing with clients about, what they allowed and what they don't allow. And they're getting more restrictive as the years go by than they used to be. Like I can remember early years where we didn't have a limit. We could pay whatever bills we incurred. And now we have a limit. We can't, if it's over $1,000, we can't pay it. We have to send it to the client. And then sometimes we have to keep contacting the client saying, we sent this to you because the vendor is contacting us because they haven't been paid. So it's not fun.
I can imagine.
So, and, again, I don't think it should be a blank check. And I don't think that attorneys should, and I don't think they do it to get rich. So they should be paid commensurate with their experience, but I don't think that they are entitled to $1,000 an hour because they're doing, quote, good work, unquote. So, but yeah, it could be improved. But I think there are a lot of resources that the general public isn't even aware of. Because there are a lot of criminal experts out there who actually do a lot of their work pro bono, and they don't charge anything. So you don't have to be a rich client. If you're indigent, they'll still work for you. Or
Yeah,
they'll
no,
work for what the
absolutely.
state is willing to pay them.
When you see that sometimes too, right? A lot of these, especially if it's a high profile case,
Mhm.
it's a good way to, it's basically, they probably get a good amount of free advertising from just being involved.
Correct. And then we're seeing now, people that are like on the payroll of the Innocence Project.
Yep, exactly.
And so when the Innocence Project gets involved, these people are there to, I mean, all the experts who testified on behalf of Rodney Reed at that last hearing all claimed that they were working pro bono. They weren't being paid at all. So, just saying.
Yeah, but it gets you invited to conferences, and it gets you press, and it helps you network and gets on boards. There's a lot of ways that they can
Yeah.
monetize.
So, all right, back to Guidry. After briefing was filed, the case was submitted on September 30th, 1997. The decision was rendered by the Court of Criminal Appeals on December 15th, 1999. The appellant challenged his conviction of capital murder under Texas Penal Code annotated section 19.03A and sentenced to death under Texas Code of Criminal Procedure Article 37071 section 2G in the Harris County District Court in an automatic direct appeal under Texas Code of Criminal Procedure Article 37.071 section 2H. A jury convicted appellant of capital murder in a case to which a husband allegedly hired a co-defendant to kill his wife, and co-defendant hired appellant to assist him. Appellant was sentenced to death under Texas Code of Criminal Procedure 37071 2G. Appellant filed his direct appeal, asserting numerous errors. The appellate court affirmed, holding that counsel's failure to object to voir dire remarks made was not ineffective assistance of counsel because the remarks were not improper. The admission of confessions did not violate appellant's rights to counsel under either U.S. Constitutional Amendment 6 because no right had attached to the murder offense when appellant had been charged with aggravated robbery, or under the Fifth Amendment because nothing suggested that his confession was not voluntary or unreliable, and appellant invoking his right not to testify was not considered unavailable under Texas Rule of Criminal Evidence 804. The outcome was that the appellate court affirmed the conviction as supported by substantial evidence, finding no violations of appellant's constitutional rights that would require reversal in the death sentence, holding that there was no abuse of discretion in denying appellant's motion for a life sentence and continuing jury deliberations. Judge Myers delivered the opinion of the court, and he was joined by Judges Mansfield, Price, Womack, and Kiesler. Judge Johnson concurred in points of error 13 and 14 and otherwise joined the opinion. Judge McCormick, presiding Judge McCormick, and Judge Keller concurred. Judge Holland also filed a concurring opinion. Judge Holland's concurring opinion, he stated he concurred in the judgment of the majority opinion and wrote separately to further clarify the confrontation clause issue presented in points of error 13 and 14. In those points of error, Guidry contends that the trial court erred in admitting statements made by Mary Gipp, appellant's co-defendant's girlfriend, concerning the appellant's and co-defendant's role in the instant offense. Appellant asserts that admitting these statements violated his rights under the confrontation clause. Judge Holland wrote that he agreed with the majority that the other statements made by the co-defendant, which implicated appellant only, are not exceptions to the hearsay rule. Therefore, they are not analyzed in the preceding manner, and they cannot be firmly rooted exceptions to the confrontation clause. With those comments, he concurred in the judgment reached by the majority. And it isn't cited in the summaries, but basically what they found was, even though Gipp's statements about Prystash's statements incriminating Guidry were erroneously admitted, it was harmless error because there was plenty of evidence corroborating Guidry's guilt, including his own statements. Because this wasn't similar to Fratta, but they even found they had the essential same holding in Fratta's case, if you remember. Because in Fratta's case, much like Guidry, his conviction was vacated by the federal court based on finding of a confrontation clause violation with the admission of Gipp's testimony. So that Guidry filed a motion for rehearing on January 20th, 2000, and that was denied on February 9th, 2000. The mandate issued on February 9th, 2000. Guidry petitioned the U.S. Supreme Court on May 22nd, 2000, and that was denied. His writ was denied on October 9th, 2000, so his conviction and sentence became final on October 9th, 2000. Guidry went on to state post-conviction, which once again was the 230th District Court in Harris County. The judge was the Honorable Belinda Hill. It may have been a different judge. The records are not quite clear. But because she issued findings of fact and conclusions of law, I put her as the judge. Gipp's his grounds for challenging his conviction and sentence in post-conviction were that Gipp's testimony about Prystash's statements were erroneously admitted. I don't know what ground 2 was because he withdrew it and it doesn't appear in again, these documents are not imaged, so I can't see his actual petition. Then third, he claimed ineffective assistance of counsel, a Batson claim regarding a challenge to a juror in his first trial. Voluntariness of his statements, which were actually issues grounds 5 and 4. Sorry. Ground 6 was challenge for cause to juror H. She said she wouldn't consider his age in mitigation or as a mitigating factor. And so he challenged her for cause, and the judge denied his challenge for cause. Challenge for cause is that they can't serve on the jury. And peremptory challenges, we just don't want them to. And then ground 7 was prosecutorial misconduct because during closing, I think in the punishment phase, the district attorney said the father was on death row. He was talking about Lex and Betty having custody of Bradley, Daniel, and Amber, and saying, they're in their 60s, they're retired, and now they're raising children again. because the
Mhm.
children's the children's mother is dead and the father's
Right.
on death row.
Yep.
The findings of
terrible.
fact and conclusions of law were issued on July 14th, 2000.
Sorry, I don't mean to interrupt and go on another
Sure.
rant, but this is one of those cases that I can't like wrap my mind around. I guess he didn't really care about his kids, right? He was just hated his wife. Like it really wasn't about getting custody of his kids because what I was trying to wrap into my mind, I know we're talking about Guidry, but if you think about fraud in the whole case,
Mm-hmm.
you know, it's just hard for me to wrap my mind around. They supposedly care about their kids, i.e., want custody, and the best way to do that is to kill their mother. It just it just reminds me how
Well,
crazy the world is, but it's more that he probably just hated his wife for taking
yeah.
his money.
I think that something that people often forget is that, especially with murder, people who commit murder also commit it with the expectation of never getting caught, or if they're caught, never being convicted. The state doesn't have the proof.
Yep.
And so I think that for Fratta, most definitely, he felt his position as a public safety officer, which involved a measure of law enforcement duties, would exempt him from being really looked at. He had approached multiple people because he wanted to muddy the waters as much as he could as to who really did kill Farah. And he thought ultimately they wouldn't be able to pin it on him, and so he'd get away with it and he'd get the kids. And I think up until he was arrested after Guidry was caught in April of 1995, that he really did, because he was challenging custody of the kids. He was trying to get control of financial uh, uh, assets that Farah had put aside for the kids. When he lost the custody, he initially refused to pay child support to Lex and Betty and had to be ordered by the judge to pay child support. And, I mean, he just thought he could get away with it, and nobody was going to believe he did it. And if they did believe he did it, they weren't going to be able to prove it. So, and if Mary Gipp had never come clean, they might not have, because they might have never connected that gun in Guidry's possession to Farah's murder.
Yeah,
But
exactly.
for Mary Gipp giving Guidry's name.
Yeah.
So,
And I'm sorry if I don't remember from the original, from the other two previous episodes, but did Fratta know that Prystash was going to outsource it to another person, or did he think Prystash was going to do it?
I do not know. I don't think that he really cared whether
Got
Prystash
it.
pulled the trigger himself. And no, I think he probably knew, because he had the $1,000 to pay Guidry and the Jeep to pay Prystash. That was the arrangement. So I think he knew Prystash wasn't going to do it directly. And then, that evening he was communicating back and forth with Prystash, was communicating with Fratta, who was in the cafeteria with the kids and then at the church with the kids. So I think all along he knew, but there was no connection between him and the shooter, so that's all the better for him. Because he can say, I don't know who that guy is. I would never have that guy kill my wife because I don't know who he is.
Because you don't know who he is.
So I was just talking and Prystash took me seriously. And I've seen that as a defense to a murder for hire plot. And I think Fratta in later appellate, in a lot of his pro se appellate claims, I think he did employ that. He said, I talked about it, and I was really angry, but I never meant it. And Prystash did it on his own, and Prystash and Gipp and Guidry were trying to frame me. Or Lex was trying to frame me. Because at one time, Fratta floated the idea that Farah and Lex paid for Farah to be attacked, not intending for her to be killed. And it went too far, and then they saw the opportunity and then Lex saw the opportunity to frame Fratta. So, play stupid games, win stupid prizes.
Yeah.
But yeah. So no, I think Fratta. I know Fratta didn't care about his kids because the only person he cared about was himself.
Yeah. Yeah. I go back to the whole, I really want custody of my kids, which implies that you care about your kids and you want to be with your kids.
No.
And then,
No.
I'm going to kill their mom. Like, it's just the
They-
insanity.
And the kids were entirely accessories to
Yeah,
Fratta
exactly.
to make him look like, and so was Farah.
Yeah.
And so when Farah had the audacity to file for divorce and leave him and be serious about it, and then to report one of the reasons she was seeking the divorce in the first place in that deposition, and that was going to become part of the record, then he was really, screwed, because he wasn't going to get custody of the kids, and he was probably going to get like supervised visitation. So, and I just noticed, my apologies to the listeners when you're listening to this on YouTube, because I did forget to share my audio. And that's why you didn't hear the intro. So I didn't share audio. So Emily our wonderful editor will put it in for the Captivate version. Off on that tangent.
All right, I'll stop distracting you and let you
No,
get back.
No problem. No problem. I need to make sure when I open Zoom that I share audio before I do anything else. Before I look for you, before I open the audio file, before I do anything, I need to share my audio. That's on me. All right. So the findings of fact and conclusions of law issued on July 14, 2000, the judge found first that Gipp's testimony, Guidry's claims were raised on direct appeal and rejected. The court went on to further analyze on the merits and found that the statements against Prystash issue interests were admissible within the hearsay exception, and that Prystash statements against Guidry's interests did not contribute to his conviction or punishment in light of his inculpatory statements and corroborating evidence. Ground 3, the court found that Guidry failed to show that the stricken jurors were subject to Batson challenge and failed to show deficient performance by his attorney. In other words, when these jurors were struck, the trial attorney did not raise a Batson challenge and did not seek an explanation for the peremptory challenges being used by the prosecutor. And that is, in order to successfully pursue a Batson challenge later, you have to establish that record at trial. And I believe, if I recall correctly, that in his appeal or his post-conviction claims, he didn't even establish the race of the jurors he was complaining about. And then ground 4, the challenge to the omission of the custodial statements had also been raised and rejected on direct appeal. The court found that Guidry failed to show in ground 5 that his written statements were taken in violation of his rights, that he failed to show that he was forced to use a peremptory challenge to strike juror H and was then forced to accept an objectionable juror Alternatively, the court ruled that youth is never a mitigating or aggravating factor as a matter of law, and a jury or a juror is not challengeable for cause if that juror will not consider age in the evaluation of future dangerousness. The challenge for cause was properly denied. Final ground 7 prosecutorial misconduct claim was raised and rejected on direct appeal. The trial judge's instruction to the jury to disregard the statement was proper in the absence of other evidence in the record that mentioned the outcome of Guidry's co-defendants' cases or punishments. And the judge recommended that the Court of Criminal Appeals deny relief. The writ was received by the Court of Criminal Appeals on October 16, 2000. And on November 8, 2000, they denied relief with a written order, which was unpublished, but which is generally not very helpful because they basically say we've reviewed the record and we deny relief. They don't go into any detail and they don't analyze unless they disagree with the judge's findings and conclusions. So at least in Texas, if I can get my hands on the findings and conclusions, it's better than having the Court of Criminal Appeals opinion. And there was an order also issued denying relief. Sorry. Okay, so he moved on to federal habeas after that. He was represented by Kenneth Anthony Williams and Robert Rosenberg initially. Williams was removed on October 31st, 2001. The venue was the U.S. District Court for the Southern District of Texas, Honorable Vanessa D. Gilmore, and the writ was assigned, the habeas corpus was assigned docket 4:01-CV-4140. It opened with a motion in order to appoint counsel, which was Williams. Guidry filed his petition on November 1st, 2001. His grounds for relief were that the state's use of Guidry's confession violated his right to be free from self-incrimination. The admission of incriminatory out-of-court statements violated Guidry's confrontation clause rights. The state violated Guidry's due process rights by referring to Robert Fratta's death sentence during closing arguments in the punishment phase, and the trial court's failure to excuse a juror violated Guidry's right to an impartial jury. The warden filed an answer and motion for summary judgment on December 11, 2001. Guidry opposed that on December 31st, 2001. On September 10th, 2002, the district court or the district judge issued an order finding that the petitioner inmate filed a petition for writ of habeas corpus. The inmate claimed inter alia that the trial court failed to dismiss an objectionable juror for cause, and that the police secured his confession in a manner which violated the Fifth Amendment's privilege against self-incrimination. Respondent warden moved for summary judgment and argued that the operation of federal law precluded habeas corpus relief. The court found that the inmate contended that trial court's determination that he did not invoke his right to counsel was unreasonable in light of the conflicting testimony. Also, the inmate pointed to inconsistencies in the police testimony that would indicate their awareness that he was represented by counsel during the interrogation. In sum, the inmate contended that the state court's incomplete determination was an unreasonable application of federal law. The court found that the warden was not entitled to summary judgment on the inmate's habeas petition because substantial factual questions regarding whether police secured the inmate's confession in a manner which violated the Fifth Amendment's privilege against self-incrimination persisted. And if the allegations in the inmate's petition, as corroborated by the attorney's testimony, were true, the reasonableness of the state court decision was suspect. Because factual development would aid the court in determining whether or not the state court's rejection of the inmate's claim was reasonable under 28 U.S.C.S. 2254D, the court intended to conduct an evidentiary hearing to determine if the inmate invoked his right to counsel. So the warden's motion for summary judgment was denied, and an evidentiary hearing was set for November 1st, 2002. Guidry filed a motion to continue that hearing on September 24th, 2002, And the court granted the motion on October 1st, 2002, resetting the evidentiary hearing to December 13th and ordering that witness and exhibit list be filed by November 22nd, 2002. Guidry filed a motion in order to appoint additional counsel. That was Robert Rosenberg. The hearing was held on the 13th of December, and then the court ordered briefing. Warden's brief was due February 15th, 2003. Guidry's brief was due March 15th, 2003. The warden filed a renewed motion for summary judgment on February 28th, 2003. Guidry responded on March 28th and filed a corrected response on April 22nd. I think Guidry also filed proposed findings for the court around this time as well, which I inadvertently deleted. On September 25th, 2003, the district judge basically granted Guidry relief on the admission of his inculpatory statements because of the irregularities during his questioning and whether he invoked his Fifth Amendment rights and whether he was lied to by the police about his robbery attorney granting them permission to talk to him. I still don't find that to be, I don't know. I still think he even if they said, oh, your attorney said we could talk to you, that doesn't mean, oh, okay, well, I'm going to make a full confession then. You know, that
Yeah,
if
I
you
don't
go
think,
through with
yeah,
it, then it's on you, not the police.
I agree. I mean, I agree to some degree, but I do think, I think for people to have faith in the system, like police have some obligation to stay within the
Yes.
bounds. Like, and I mean, I'm a little nervous. I guess I'm not though, but like I've honestly struggled with the idea that they can lie. And to me, I guess that is okay because again,
Criminals
I'm
don't
I'm
tell the
sure it
truth.
can be, yeah, it can be abused. So it is a little bit unfair that, hey, police must be 100% honest while, the criminals can lie. But I think when right to an attorney is such a fundamental right, I think denying that by saying,
Mhm.
oh, it's okay, tricking him, because a lot of these
Yes.
people may not be sophisticated. And if he had asked for an attorney, the attorney would have said, hey, shut up, don't confess. And that's where I think it does cross the line for me. I'm like, actually, I think the ruling is correct on that one. I think lying about your attorney said it's fine is a bridge too far versus saying, hey, we got your fingerprints at the scene.
Right. Right. And I kind of agree, but I kind of don't agree because again, you know, and Guidry, this wasn't his first rodeo. This wasn't his first criminal charge. This wasn't his first time in jail. So, again, yeah, he may have been tricked. He probably was tricked. But that he followed through and then makes these inculpatory statements, and not only verbal, but written statements. And he initially, when he makes his first statement, he tries to say he was a getaway driver. So he tries to lessen his own culpability. And then when they kind of say, well, we know that's not true because the witnesses saw, a black male get into the car and a white male driving the car or, whatever, or a black male with a big head and that fits you to a T. He, finally admitted to being the shooter. But again, the district court, it made its ruling and it also found the confrontation clause with Gibbs repeating inculpatory statements made by Guidry that were hearsay to her from Prystash. So that was the other ground. So they granted Guidry's petition in part, denied denied it in part, and denied the warden's motion for preliminary judgment. The judge also denied a COA. The warden filed a notice of appeal on October 1st, 2003. He also filed a motion to stay so that Guidry would remain in jail. And that was granted on October 14th, 2003. They went to the Fifth Circuit Court of Appeals. And basically the Fifth Circuit affirmed the district court's grant of conditional habeas relief to Guidry, finding that the district court's conclusions were correct. Without the confession and challenge hearsay, there was insufficient evidence to convict Guidry of murder for remuneration or promise of remuneration. Now, there was a dissent filed, and that's what, when we were talking about Prystash's case, that is what Prystash tried to argue, is that or maybe the state tried to argue, I think the state tried to argue that the Fifth Circuit found that the district court should not have held a hearing, an evidentiary hearing, because EDPA restricts the ability of the district courts to hold hearings. And I think Guidry's case falls right after EDPA's enactment, because it's based on, if you're convicted after EDPA is enacted, you are subject to EDPA. If you were convicted before the enactment, then the prior 2254 is what your case is reviewed under. But anyway, so that's where there was a dissent issued, basically, and this was on October 25th, 2005, which found that the hearing should not have been held by the district court, or argued that the hearing should not have been held by the district court under EDPA, and that the district court should not have rejected the fact findings of the state courts because they were entitled to presumption of correctness unless they were proven incorrect by clear and convincing evidence. And, they didn't find that holding a new hearing and reevaluating all the testimony of all the witnesses outside the state court record was the way to go. But that's a dissent. It has no legal impact. Just as, like in the Kevin Cooper case, the dissent by all those Ninth Circuit judges means zero in his case, because ultimately the Ninth Circuit denied him relief and found his conviction and sentence were just. The warden filed a petition with the U.S. Supreme Court on January 23rd, 2006. They held a conference on March 17th, 2006, and they denied that petition on March 20th, 2006. Their mandate issued on March 28th. Their judgment was affirmed on April 18th, 2006. And so the case was remanded back to the state court for a retrial. However, Guidry, not satisfied, filed notices of removal trying to move the criminal case from state court into federal court. And he filed those notices of removal on January 29th, 2007 and January 31st, 2007. He also filed a motion seeking release from prosecution, basically saying that the federal court was going to bar him being retried by the state of Texas. On January 31st, the district court issued an order denying Guidry's motions and remanding his criminal case to state court. On February 1st, 2007, Guidry filed a third emergency notice of removal, motion to enforce court's judgment, and motion for clarification. And once again, on February 2nd, 2007, the district court denied Guidry's motions to invoke federal jurisdiction and, said case goes back to Texas. Now, during this time, Guidry was also challenging a retrial in state court. He was represented once again by Alvin Nunnery and Loretta Johnson Muldrew, and it was back in the 230th District Court in Harris County, Texas. Judge Shaver was appointed as the new judge for this criminal trial. I believe they had a lot of cases and a lot of courts in Harris County and not enough people, not enough judges, which required the chief judge of the district to appoint judges from other jurisdictions within the district to come and hear cases in Harris County. And that's how the old circuit courts used to work, where the judge would go to different counties. And in Arkansas, the circuit courts are like that because Judge Burnett was in Craighead and, heard cases in Craighead, Crittenden, and multiple counties within the district in Arkansas. That's how circuit courts worked. Guidry was returned to the Harris County Jail from death row on April 12th, 2006. His attorneys filed another petition for habeas relief in state court. That was denied on May 12th, 2006. He was re-indicted for capital murder on June 16th, 2006. The state also filed a motion to amend that indictment on June 23rd, 2006. Basically, they sought to add that Guidry intentionally caused Farah's death by shooting her with a deadly weapon, a firearm. The motion to amend was granted on the same date, June 23rd. Now, the state, even though they didn't have Guidry's inculpatory statements anymore, and they still had Gipp's testimony to a point, but she could no longer repeat any statements that were incriminatory as to Guidry or any statements Prystash made, allegedly made by Guidry. They still had, her seeing Guidry waiting for Prystash on the stairs, dressed in black. They still had her seeing Prystash and Guidry leave. There are elements of her testimony that were based on her firsthand knowledge that remained good evidence. But they had to limit the statements that she could repeat at trial. But by this point, they also had some new evidence. First of all, during the pretrial proceedings or during the pretrial period, at his first trial, Guidry was evaluated by a mental health expert who interviewed Guidry and made notes and rendered a report. More likely than not, because that expert was going to testify at the trial during punishment phase, that expert, at least to his report, possibly also his notes, became discoverable to the prosecution. And in the report, he says Guidry admitted to shooting Farah. So during his cross-examination at the first trial, the district attorney, probably Miss Kelly Siegler, said, well, Dr. Bassinger, when you interviewed Howard Guidry, he told you he shot Farah. And because he's testifying under oath, all he can say is, yes, he did. So they have that. And they can bring that in because that's an admission against interest. It's a hearsay exception. Then also, while in jail awaiting trial, Guidry had numerous telephone conversations with a freelance journalist, and I put that in quotes because she's not really, Gloria Ruback. Anyone who's watched or listened to Execution Watch Gloria Ruback is a woman standing outside of the prison walls at Huntsville when an execution is carried out in Texas with a bullhorn, talking to the person about to be executed, giving messages of support to the family of that person, telling the state they don't have to do this, they don't have to kill it, how killing's wrong. She is an anti-death penalty advocate. Big time.
Yeah,
So,
I looked at her. Yeah, she seems to be one of those people that took lunacy and said, "Hold my beer," and just kept going to the crazy train.
exactly.
I mean,
You
she's
said
like
it, not
basically
me.
she's like the QAnon. Like she just believes
Mhm.
everything's a wild conspiracy theory.
Yeah. But in these calls, he made inculpatory admissions to Ruback, to having shot Farah, having killed Farah, having, sought money from Fratta. I mean, and there were a lot of conversations, and those were admissible at Guidry's trial. And, you should have had those conversations, sweetie, because at the beginning of the call, you're warned that you're being recorded and that anything you say can and might be used in court. So that's on you.
Yeah, she seems just like the kind of dingbat that doesn't even know the basics. You know, she's out there screaming but doesn't know the basics that your conversations are recorded and not at
Yeah.
least to say, hey, don't say anything.
So yeah, and pardon me, we'll talk a little bit more about that and Ms. Gloria later. So initially, Guidry's trial was set to begin in July of 2006. When the state announced its intent to have Scott Bassinger testify, there were hearings because, of course, Nunnery and Muldrow filed motions trying to keep it out. And basically their argument was that because the first trial had been thrown out, any inculpatory statements made by Guidry, no matter who they were made to, could not be used in his next trial because the federal district court had said no. But that's not the case. Guidry's statements to police could not be used, but his statements to Bassinger had nothing to do with the police conduct. Bassinger was not a state expert. Guidry was not being compelled to talk to Bassinger by the state, and therefore any statements he made to Bassinger were admissible. Nunnery tried to argue that after the inculpatory statement during cross-examination was reported during the first trial, that he approached Bassinger outside the courtroom, and said, "What was that about?" And Bassinger said, "Oh, I got confused. I thought she was talking about the material I had read." So in other words, Bassinger was saying, Howard Guidry didn't really tell me he committed the murder. I just read that he said he committed the murder.
Yeah, and I've got some oceanfront property in Arizona to sell you.
Yeah, right at El Paso, right?
Yeah, exactly.
On the Pacific Ocean in El Paso. So, all right. So Nunnery, believing he was now a witness to keep Bassinger's testimony out, withdrew as counsel, but then never ultimately testified about this alleged statement by Bassinger. Nor was he called by the new attorney, who was Tyrone Moncrief, who was appointed on July 20th, 2006. So the trial was moved in July of 2006 to begin on January 29th, 2007. Guidry's attorneys filed a motion to continue on January 29th, 2007, alleging that they had insufficient time to prepare for trial. Pardon me. And one of the reasons they were saying that they had insufficient time was, by this point, Gloria Ruback and her calls with Guidry had become Exhibit B or Exhibit A by the state, and they did not have time to listen to the recordings in full and to find their own excerpts that they wanted to admit, or to challenge the credibility of the statements made during those conversations, or to impeach the credibility of those statements. They needed more time, and there was apparently, at the time, the district attorney received the calls from the jail in a medium that they could not duplicate, and that could only be played on a computer within the district attorney's office, like a workstation within the office. That is kind of an unreasonable system, and I think it has been changed since then, but at that time, and so that was the big challenge, was the time to go listen to the recording, because they weren't going to get a CD with all the recordings on them to listen to at their leisure. They were going to have to go to the DA's office. I don't think that's really a material issue that affects fairness of Guidry's trial one way or the other. It's an inconvenience, but it could be done, given the fact that the district attorneys had to do it as well, because they couldn't listen to the recordings anywhere but within their own offices, on their office equipment. They couldn't listen to it like on their laptops that they brought home. And there were hearings on this issue, by the way. I read excerpts of transcripts regarding the issue. So that was denied on January 29th, 2007. The court wasn't going to delay. And, again, people forget that when you're facing criminal charges, especially when you are confined in jail, you have a right to a speedy trial, governed by the Constitution as well as often by state law. And in a lot of states, that's 9 to 12 months. If your trial doesn't commence within 9 to 12 months, you can have the charges dismissed. And in some states,
Right.
there's no wiggle room if the defendant is the one seeking to continue. Now, in other states like Arizona and Florida, they have a lot of pretrial discovery in place, and so that often delays the trial. But it sounds like Texas is pretty basic, and they do try to get them to trial within 1 year of arrest or indictment, to the extent possible. So the trial, that motion to continue the trial was denied. The trial was scheduled to begin on February 19th, 2007. And there's a note in the file that basically acknowledges that the federal court reversed and remanded Guidry's case and vacating Guidry's original conviction in the criminal case in Texas. The guilt-innocence phase began on the 19th of February, 2007 and concluded on February 22nd, 2007. February 22nd, 2007, the jury found Guidry guilty of capital murder. He filed a renewed motion to continue on February 26, 2007, alleging that his counsel had been given insufficient time to prepare for the penalty phase, and citing a lack of resources and necessary records that they had not yet been able to obtain. Again, long motions, excerpts of testimony, affidavits out the wazoo from legal experts and death penalty experts who said that, the time given had just not been enough to prepare an adequate mitigation case, and that was impairing Guidry's rights to a fair trial. That was denied again on the 26th of February, 2007, and the penalty phase commenced. I don't know what the special issues were. One is probably future dangerousness. there were 2 special issues in this one. Both of jury voted yes on both, but again, I don't know what I don't know what they were. And then the jury voted no on the mitigation special issue. In other words, they didn't find that the evidence presented in mitigation outweighed the aggravating evidence against Guidry. And the jury sentenced Guidry to death on March 1st, 2007. In his direct appeal to the Court of Criminal Appeals, he was represented by Loretta Johnson Muldrow and Terrence Geiser. He raised points of error 1, 2, and 3 that the trial court erred in admitting the testimony of Scott Bassinger in violation of Guidry's rights under the Fifth Amendment, freedom from compulsory self-incrimination, and that his statement was admissible under Article 38.23 of the Code of Criminal Procedure as fruits of violation of Guidry's right by detectives. Points 4, 5, 6, and 7 were that the court's charge to the jury denied his right to a unanimous verdict on the alleged aggravating factor, thus violating several constitutional provisions, including the Sixth Amendment and the Texas Constitution. Point 8 was denial of a fair trial because the charge allowed the jury to convict without agreeing unanimously whether the defendant committed murder for remuneration or murder in the course of committing a burglary. Points 9 and 10 were that he was denied his right to effective assistance of counsel of the Sixth Amendment because his attorney neither objected to nor requested a hearing on the admissibility of the testimony of Mary Gitt McNeil. Point 11, that the trial court erred in overruling Guidry's objection to the state's exercise of peremptory challenge in violation of the Equal Protection Clause of the 14th Amendment. Points 12, 13, and 14, the trial court erred in overruling Guidry's objection to the admission of testimony about the effect of extraneous offenses on the victims of those offenses in violation of the Eighth Amendment and in violation of the Due Process Clause of the 14th Amendment. The appellant's brief was filed on February 5th, 2008. The appellee's brief was filed September 15th, 2008. Motion to supplement the record was filed by Guidry on October 6, 2008, and that motion was granted on October 16th. Motion to reset oral argument and an order were filed and granted on October 28, 2008. Now, I don't find any evidence that the case was actually argued. I don't find an oral argument date. I don't find any notices of appearance or anything like that in connection with oral argument. Sometimes the Court of Criminal Appeals will schedule argument and then will send out a notice that they're not actually going to hold argument at all. So that looks like what may have occurred. The records at that time were not fully imaged, so you have to kind of just look at the docket and try to divine what occurred. The opinion of the Court of Criminal Appeals was issued on October 21st, 2009. It was an unpublished opinion, and essentially his conviction and sentence were affirmed, and points of error 1 through 14 were overruled. And then he filed a motion for rehearing, but that was denied on January 13, 2010, and the mandate issued on February 1st, 2010. Went on to state post-conviction, and he was represented by attorney Jerome Godnich Jr. Again, that was the 230th District Court in Harris County. Honorable Belinda Hill, again, presided over the state post-conviction. Guidry sought an extension of time to file his petition on October 7th, 2008, and that was granted on October 8th, 2008. He filed his post-conviction application on January 28, 2009, and he alleged that the trial court erred in overruling his objection to the state's peremptory challenge of Juror W under the authority of Texas Code of Criminal Procedure, Article 35.261, and Batson versus Kentucky in violation of the Equal Protection Clause. In that instance, they did do a Batson challenge. The prosecutor gave a non-discriminatory explanation for striking that particular juror. The court accepted those as race neutral, and then the burden shifted to Guidry to disprove those explanations or disprove to prove that the strike was racially oriented, which he didn't do. Claim 2, the trial court erred in admitting the testimony of Dr. Bassinger, who testified that in Guidry's prior trial, Bassinger testified that Guidry told him that he shot Farah Fratta because Guidry's alleged admission was the fruit of the violation of Guidry's rights under the Fifth Amendment and were inadmissible under Article 38.23. Guidry filed a supplemental application claiming that the trial court erred in overruling his peremptory challenge, claiming that they erred in admitting Bassinger's testimony and adding that he was denied the effective assistance of counsel under the Sixth Amendment of the Constitution when the counsel failed to object to the testimony of Mary Gitt McNeil that was based on hearsay and denied his right to confrontation. Findings of fact and conclusions of law were issued on March 14, 2012, in which Judge Hill found that the Batson claim had been raised and rejected on direct appeal. Also found that Guidry failed to show that the trial court erred in finding the state's stated reasons to strike juror W were race neutral, failed to show Batson error, and failed to show disparate treatment between juror W and other jurors. And that basically, they looked at other jurors who had the same church affiliation, were African American or Hispanic, to try and show that juror W was treated differently than these jurors. So it's really interesting. The findings of fact are very long, and there is a really detailed analysis of each of these jurors, their answers during voir dire, and that, you know, they were accepted as jurors by the state or not accepted by jurors by the state, or not accepted by Guidry. So it's really a detailed analysis, and I'm not going to go into it here, but it is, again, the findings and conclusions in Texas can be really involved and really detailed. And if you can get your hands on them and you're interested, you should read them.
Yeah, jury selection is fascinating. Just the psychology and the strategy behind it. It's another one of those quirks of the system of how that can be such a important, maybe sometimes the most important part of the process, even more so than the actual arguments.
Then the second conclusion was that Bassinger's the claim about Bassinger's testimony was raised on direct appeal and rejected. The court also found that Guidry failed to show constitutional violation of his rights by Bassinger's testimony and failed to show that his case was analogous to Harrison, in which a criminal defendant was forced to testify when his illegally obtained statements were admitted at his trial. The court found there was a sufficient break between the illegal actions of the police and the retention of Bassinger as a defense expert. And again, they found because he was a defense expert, Guidry wasn't compelled to speak to him. It was in his best interest to speak to him because Bassinger was working on behalf of Guidry. They also found, the court found that Guidry had failed to demonstrate that his conviction was unlawfully obtained and failed to show that the claim about ineffective assistance of counsel related to Gibbs' testimony could not have been raised in his initial application and was dismissed as an abuse of the writ. Pardon me. The court entered an order transmitting his post-conviction writ to the Court of Criminal Appeals on March 14th, 2012. It was received as two different writs. The first was received on April 12th, 2012, and that was given writ number 47417-02. The second was received the 23rd. That was probably the amended or the supplemental application on April 23rd, 2012, and that was 03 writ. The Court of Criminal Appeals on June 27th, 2012, issued a written order opinion denying relief and dismissing the supplemental writ as an abuse of the writ. So he could have raised ineffective assistance of counsel related to Gipp's testimony in the first writ that he filed, and he didn't. And he raised it on direct appeal as well. So he knew about it and could have included it in that writ, and he didn't. Then, somebody thinks of it and they file a supplemental writ. On federal habeas relief, he went to federal habeas court. He was represented by Gwendolyn C. Payton, Tyrone Moncrief, and Edward A. Mallett. And those of you West Memphis 3 people might recognize Mallett's name from Damian Eccles' state post-conviction claims.
There he is.
There he is. Yep. But he's dealing with a Texas case, which he was a Texas attorney. It was again at the United States District Court for the Southern District of Texas. Same judge, Honorable Vanessa D. Gilmore. There was a miscellaneous case filed in 2012 that was appointing counsel, and then a civil case was filed in 2013, and that was where the actual writ for the petition for writ of habeas corpus was filed. I'm not going to go through all this. There was a motion to appoint filed by Godnich. That was granted. Payton and Mallett appeared in August 2012. Payton filed a motion to appear as the attorney in charge, which was granted on August 18th. The petition was filed on June 26, 2013. There were multiple affidavits and declarations. Some were from Guidry family members who complained about the trial attorneys not speaking to them, talked about Guidry's youth and medical conditions and growing up and, troubles in his life and struggles of his family going back generations in Vermilion Parish. Yes, Vermilion Parish, Abbeville, Erath, those towns were heavily segregated up until the 60s or 70s. There were struggles for African Americans during those times. And they, of course, I guess it's a basis. I mean, yes, his mother had to travel from Erath all the way to Abbeville to go to high school. I'm not saying it was right or wrong. It's how it was. And we can't judge it based on the morals of today.
Yeah.
I think we do everyone a disservice to judge what was being done then by the morals of today. Yes, we know it's wrong, but that was the world that they lived in. And I think it discounts their achievements of people who went to school, went to college, became the first African-American lawyers or the first African-American doctors or the first African-American judges, because they had a challenge to get to where they got. And instead of making it seem like they were victims, let's look at it as a triumph. In spite of the challenges, they managed to do great things and get, to places that a lot of people would not have gotten to.
Yeah, no, absolutely.
Because they would not have been able to meet the challenges.
Yeah. And I mean, the reality of the world is, right? I mean, most, life isn't fair, right? Everybody is on some continuity where things happen to them, but there's a lot of people that have to face really terrible things. Sometimes they're societal, sometimes they're personal, but yeah, we should celebrate people, especially those that can overcome,
Right.
headwinds, whether personal or societal.
Yeah. So, and then there were also the attorneys that they didn't have enough time to prepare. They didn't have enough time to get the records that they needed, that the mitigation case was inadequate because of the court refusing to grant continuances. I mean, there were multiple issues encompassed in these declarations. And one of the funniest ones, and the one that I think is going to ensure that when Gloria Ruback passes on, even though she thinks she deserves a reward for the good things she's done, she's going to find not so much, because in her declaration, which is supposedly the truth under oath, she says that the recordings admitted by the state were spliced together to make it sound like Howard Guidry made inculpatory statements that he never made. So that is like liar, liar, pants on fire. And that, he never made admissions to her. Of course, interestingly enough, she did not turn over her notes. And you can hear on some of the recordings in the testimony and in the because she testified at hearing, you can hear her typing. And she's like, yeah, I was on my laptop taking notes. But she never turned those notes over to the defense to help them challenge the admission of these statements or the recordings. So, you got to wonder, did she really want to help Howard Guidry, or does she just want to, make up stories? And if you read some of her stories, there was a hostage situation on death row around 1998. And another death row inmate and Howard Guidry took a correctional officer hostage and threatened her life. And if you read Gloria Ruback's quote, report, unquote, they were doing this to bring attention to the deplorable conditions of death row and to make their voices heard. And, it wasn't wrong. It was right. It was protest. Like, people burning the Wendy's where the Atlanta police shot the guy sleeping in his car in the parking lot when he tried to drive away. That was protest. Destroying Ferguson after Michael Brown was shot by the police officer, that was protest. So, off my soapbox before I fall.
No, but it's that, it's like, hey, we're upset. So what are we going to do? We're going to burn down the small businesses of all the people that were willing to come here and do business in maybe a less than desirable neighborhood, but we're going to burn down their business. And then we're going to complain why there's not a pharmacy or a grocery store in our neighborhood.
Correct. So anyway, an order was issued by the court on September 10th, 2015, making requesting that the warden file an answer in 60 days from entry of the order. The warden filed a motion for summary judgment on November 9th, 2015. Guidry opposed that on December 9th, 2015. The court ordered additional briefing from the parties on June 14th, 2016, which were filed on June 25th, 2016 by Guidry and the warden with briefs and exhibits. And on August 30th, 2016, the court denied the motion for summary judgment from the warden without prejudice. And it stayed and administratively closed the case, ordering Guidry to expeditiously seek state relief and move to open the case within 30 days of the conclusion of state review if necessary. So Guidry had raised in his petition, which I didn't have, unexhausted claims that needed to be exhausted in state court. So he was sent back to state court because in federal habeas, you have to give the state the first opportunity to correct its wrong. So Guidry went back to state court on October 31st, 2016, and filed a subsequent application for state post-conviction relief. He was represented by Ruth Lee Johnson, Gwendolyn Payton, and Edward Mallett. She filed a notice of appearance, but Ruth Lee Johnson didn't appear to be too active. Perhaps because Payton was an out-of-state attorney, she was filing to get Payton admitted in state court. Anyway, they were back in the 230th District Court, and the judge was Brad Hart. Guidry raised a lot of claims, and I'm just going to run through them very quickly. He alleged suppression of evidence, which was Brady violations related to fingerprints, hypnosis of eyewitnesses, ballistics evidence. He alleged there were confessions of other suspects. A man by the name of William Planter, who was actually accused, convicted, and later his conviction was vacated. He was alleged to have tried to hire himself to Lex Baquer to kill Fratta prior to Fratta's arrest and charge for capital murder. So, but apparently somewhere in the record, in the records of the investigation, there was an alleged confession by Planter that he was the getaway driver. There was a man by the name of Mann, M-A-N-N, who was implicated by evidence as a shooter, although, again, this is something they found in the state investigatory records or investigatory files that wasn't sufficiently detailed in what the written evidence I could find to tell me exactly what evidence implicated him as a shooter. And it's possible that these were the cuckoo allegations being made by Fratta that Guidry was glomming onto. Guidry claimed that Mann also alleged that a man named Kevin Miller, who died by suicide shortly after Farah's murder, committed the murder. He alleged that fingerprints at the scene matched another young black male who was named Barlow. But it turns out they tried to allege that the fingerprints were found on Farah's car. They were actually found on Podorsky's car. Podorsky was one of the people who Fratta tried to hire to kill Farah. He was another gym rat or worked at the gym. And the fingerprints were found on his car. Why Vernon Barlow's fingerprints were on his car, no say. He alleged ballistics evidence was exculpatory, and that's basically that the ballistics evidence was inconclusive. Inconclusive isn't necessarily exculpatory.
Right, exactly.
He alleged
it's the reverse. Yeah, it's the reverse of all the DNA evidence is consistent with 1 in 20 million. Doesn't mean it's not you, but it certainly doesn't mean it is you. So yeah, it makes a lot of sense.
Well, that's a little different, but
no, I'm just saying it's kind of the same side of the coin. It's like, just because it proves it wasn't your gun can't prove it was your gun doesn't mean it was not your gun.
Disproves that it was, because DNA, the 1 in 5 billion means you would have to pull 5 billion random people off the street to get the DNA profile that they found. That's what that means. So like 1 in 250 means every 250 people would have this DNA profile or could have the DNA profile. So, and really when it's 1 in 5.5 billion, it means it's your DNA. Or 1 in 20 million, it means it's your DNA. Because there's not even 20 million people in the jurisdiction to randomly pull people off the street. So just to clarify that, just very quickly. He also alleged a late disclosure of the Ruback recordings prevented Guidry's counsel from preparing for and impeaching the state's skewed preparation of the evidence. He alleged ineffective assistance of trial appellate and state habeas counsel in failing to keep Gipp's testimony out, failing to suppress her testimony, failing to raise the trial court's violation of confrontation clause rights, and allowing Gipp to repeat information from Prystash. Failing to offer prior inconsistent statements to impeach Gipp, making Bassinger's testimony available to the prosecution, failing to raise Dunnery's ineffective assistance to suppress Bassinger's testimony, failing to respond to Bassinger's testimony, failing to investigate details of the crime and the eyewitnesses, failing to investigate the Ruback recordings, ineffective assistance of counsel at the punishment phase, inadequate mitigation presented, and cumulative error of all these errors or all these ineffective assistance errors. Ground three was yes. Sorry.
No, I was just saying, I mean, being Captain Obvious, again, you really understand when people say that death penalty cases end up costing the state more money than, life in prison. I mean, just the amount of appeals. It just always, I know we've done a bunch of these. It just continues to amaze me, all of the paperwork that goes into these.
Is because the people who are sentenced are utilizing the processes and procedures available to them.
Yep. Exactly.
It's not the state's fault for seeking the death penalty.
Oh yeah, no, I agree. I'm not. I'm just saying. I'm just continually amazed at all the appeals.
I can promise you, look at Pamela Smart. She's not sentenced to death, but she has utilized processes and procedures to challenge her sentence. She's alleged that her sentence isn't fair because the people who actually carried out the murder didn't serve life in prison and are all out of prison. And if death penalty goes away, people sentenced to life are going to utilize the procedures to challenge that. And that will be the next challenge. And, pretty soon we'll be looking at, it's not fair to sentence somebody more than 10 years for a murder, or those arguments to be made. So, it is more expensive, but that's because they utilize the procedures and the processes and often have their legal counsel paid for by the state. So it's a necessary evil. His third ground for relief was that Bassinger's testimony was wrongfully admitted because it was a fruit of unconstitutional actions of police in violation of the Fifth Amendment. It came in due to unconstitutional actions in the first trial, the Fifth Amendment violation, and trial court improperly admitted Bassinger's testimony. In ground 4, he alleged she was denied a fair and impartial jury because of a Batson violation with regard to striking of juror W. He alleged jurors knew about his prior conviction and sentence. He alleged that the trial court failed to instruct the jury about compensated witnesses because apparently there was a jailhouse snitch that was compensated, although I don't know whether he ever actually testified. There was a denial of counsel of choice violating the Sixth Amendment and the 14th Amendment, and that is because during his initial state post-conviction, he raised complaints about Godnich not raising issues he wanted raised. And he wrote to the judge trying to get the judge to assign another attorney, and she wouldn't do so. And I think he wanted an attorney who wasn't admitted to practice in Texas. But don't quote me on that.
Why would that just be so he could waste more time? Like, what would it be?
And I think there's a misconception. If you are being represented by state counsel, by counsel appointed by the state, you're not necessarily entitled to say, I want the state to appoint Joe Blow. You get who the state appoints to you.
Right.
And you can't say, I want a specific attorney appointed. Now, if you have an attorney come in and he's willing to work pro bono, you can get rid of your state appointed counsel, but you're not entitled to say, well, I want this guy to represent me and y'all to pay him to represent me. He either has to agree to represent you pro bono and not be paid, or you stay with who was appointed by the state. You're not allowed to counsel of choice when you have appointed counsel, not necessarily anyway, or at least not in Texas. He also finally, in his sixth claim, alleged that his execution would violate the Eighth Amendment under Lackey because he'd been, it was 25 years since the crime and more than 20 years since his original conviction. And that's one of those that, too bad, so sad, you would utilize these procedures, and so you're dragging out your time on death row. That's not on us, that's on you.
Right.
There is a Supreme Court memorandum opinion by one of the liberal judges who opposed the death penalty, saying it wasn't fair after 18 years to execute this person. He should have been executed before now. And since he wasn't, he shouldn't be sentenced to death. His death sentence should be vacated and he should be sentenced to life in prison. Lackey, it's a case called Lackey versus Texas. And we may do a show at some point. I can't bear to deal with Texas anymore or Oklahoma right now. But we may eventually look at Martinez, Trevino, Lackey, some of these Texas cases that have gone to the Supreme Court and resulted in arguments like this. Even though the basis has no binding precedent on anybody or anything. He filed an amended application with additional allegations regarding trial counsel's ineffective assistance of counsel due to workloads. I tried to compare the summary of issues and grounds from that amended application with the initial application, and that's really the only addition I could find. I could be wrong that there are additional claims raised, but in comparing line by line, count by count, that was all I could really come up with, that his attorneys failed because they had too many other cases that they had to deal with. The state filed a proposed order under 11.071 Section 5B in 2017. On August 24th and into August 25th, 2017, Hurricane Harvey made landfall in Texas and did significant damage to the Houston metropolitan area. And apparently one of the things was that the state's 11.071 order was lost. So on February 18th, 2019, the state filed a renewed motion and proposed 11.071 Section 5B order. Then it looks like the writs kind of petered out. Relief was perhaps denied by the Court of Criminal Appeals without a written order, because the next thing I find is that the motion to lift stay and everything was reopened in 2018 in federal court. So Guidry went back to federal court. He was represented by Gwendolyn Payton, Edward Mallett, who was terminated on August 14th, 2017. W. Allen Wright was substituted on August 14th, 2017. A notice of appearance was filed by Lisa M.C. Elizondo on August 26, 2017. And then an attorney by the name of John R. Nealman appears on the docket summary, but I don't really find anything specifically done by Attorney Nealman. The stay was lifted on October 15th, 2018. The court requested a joint scheduling order on October 18th. A joint discovery and case management plan were filed on October 29th. The scheduling order was amended on November 26, 2018. Guidry filed an amended petition on January 25th, 2019, adding the suppression of material evidence Brady violations related to fingerprint, hypnosis of witness, ballistics evidence, confessions from planner man Miller being implicated, and the late disclosure of the Ruback recordings, a false evidence claim, an ineffective assistance claim of trial, appellate, and state post-conviction counsel, an allegation that Bassinger's testimony was wrongfully admitted, denial of a fair and impartial jury, denial of counsel of choice, and that his execution violated the Eighth Amendment under Lackey. Again, multiple declarations were filed by trial counsel, Ruback, jurors, witnesses, and Guidry's family members. They had jurors who said, if I'd known that the ballistic evidence didn't tie Guidry to the gun or didn't tie the gun to the murder, I wouldn't have convicted Guidry. We didn't know that. And they usually don't accept those kind of, they don't even look at those kind of things. Other jurors said, if I'd known about him eating mercury-tainted fish, I wouldn't have sentenced him to death. Again, they usually don't look at that because often what jurors and witnesses are presented with is a skewed version. They're presented with the defense version of the facts without any input by the state. And so often, humans being who they are, well, if I'd known that, I probably wouldn't have convicted him. But you can't really say. And sometimes they're presented with things they didn't know that actually were admitted at trial. They just forgot.
Yeah.
So, and Ruback, repeated her allegation that the recordings admitted by the state were cobbled together from bits and pieces, and that Guidry never ever confessed to her.
Yeah, I've never liked that. I've never really liked that post conviction, 25 years later juror interview that I wouldn't have convicted. It's just that's like comparing apples to orangutans. I mean,
And-
it just what are you if you're that juror, if you say, oh yeah, I still would have convicted him, somebody might yell at you, but you just play the game and be left alone.
And sometimes you get one or two jurors, but then you get other jurors that, refuse to sign your affidavits. And the interesting thing, the jurors and a lot of these witnesses' affidavits were handwritten, although not necessarily by the proponents, by the jurors themselves. Because like a lot of the jurors' affidavits were handwritten in the same handwriting from one juror affidavit to the next. And they also had the Holshers, or at least Laura Holscher, they had her kind of qualifying her testimony in Guidry's trial. But they don't usually work, but the defense bar continues to try. Guidry also filed a motion for discovery, and the warden filed a motion for summary judgment on May 28, 2019. He also opposed the motion for discovery. Guidry filed a reply in support of his motion for discovery on June 27, 2019. He filed a motion to amend his petition rather. He also filed a motion for an opposition to the motion for summary judgment on August 26th. In the motion to amend his petition, he added that he was denied a fair and impartial jury because jurors knew he had previously been convicted and sentenced to death, and he alleged that was a claim inadvertently omitted from his amended petition filed when the habeas case was reopened. I've already cited the notice of appearance by Attorney Elizondo. The opposition to the motion amend was filed by the warden on September 6, 2019. And the court issued an order denying the motion for discovery on the same date. Guidry filed a motion in support of his motion to amend on September 13th, 2019. On the 19th, the court granted Guidry's motion to amend, finding that the amendment would unnecessarily delay the action, but that the court would consider the red line portion of Guidry's proposed second amended petition as a timely supplement to his amended petition. And he relied on, the court also said that she would rely on the respondent's earlier briefing relating to the red line text and adjusting the pending summary judgment motion. On April 13, 2020, the court issued a memorandum in order granting the motion for summary judgment, denying Guidry's cross motion for summary judgment, which was probably part of his opposition or response to the warden's motion, and denying his federal petition for writ of habeas corpus. The court dismissed the writ with prejudice and would not certify any issue for appellate review. A final judgment issued denying Guidry's petition and dismissing it with prejudice, and no certificate of appealability would issue. Guidry appealed to the Fifth Circuit Court of Appeals on April 22nd, 2020. The appeal was lodged as docket number 20-70005 at the Fifth Circuit Court of Appeals. There were appeal review notes issued or entered in the district court, which appears to be something being done in the Texas district courts that I don't see in other state district courts, U.S. district courts in other states. An unpublished opinion was issued April 21st, 2021, essentially denying the court the certificate of appealability on the grounds that jurists of reasons could not disagree with the district court's denial of petitioner's Batson claim, as petitioner could not show that the trial court committed clear error in finding no discriminatory intent. And one of the allegations as to the discriminatory intent was that Juror W was a member of the NAACP. And he traveled from Houston to his parents' home to attend NAACP meetings and didn't miss them. And because he was African American, they felt that this was per se discriminatory. But the membership in the NAACP was one factor cited by the prosecutor in the Batson claim, or in response to the Batson allegation at trial. There were other things. There was his church membership, which basically the prosecutor found that members of that particular church, which was Joel Osteen's church, and it was his father's church before, that they were a little nutty in the prosecutor's view. And also his statements about having been discriminated against and having been denied promotions and having been denied advancements by Caucasian individuals because he was African American. And his attitude toward those things was something that gave the prosecutor pause. And also there was a person who was an activist and an anti-death penalty, and it was the NAACP's opposition to the death penalty that was cited as being one of the reasons the membership in the NAACP was troubling. But there was another activist, a local Harris County, Houston activist, who was listed as a witness by Guidry, and who this juror claimed to know personally, I believe, that also was a reason that the state felt that he should not serve as a juror. And the NAACP's opposition to the death penalty is a valid reason, because jurors are not supposed to be only fair to the accused. They are
Right.
supposed to also be fair to the state. And if the state is seeking a death penalty and you've got someone who opposes the death penalty and cannot consider it as a valid sentence, then that's not fair to the state, and
Yeah.
that person should not serve on the jury.
Well, I mean, at the end of the day, right? I mean, they generally have their
Yeah.
particular number of strikes, and they can kind of use them how they want to.
Yeah. And
I mean,
often,
if the
well,
guy's
they
left-handed,
have to,
you could potentially do it.
but they have, if the defendant alleges that the strike is based on race, they have to show that the strike is not based on race. They have to give race neutral explanations.
Got it. No, that makes sense.
And then if and then the burden shifts to the defendant to say those explanations aren't real, they aren't right, they aren't correct, and it's really race. And the court has to kind of weigh those and decide whether the explanations are race neutral or not. And I think a lot of people don't realize is when you have somebody who is morally opposed to the death penalty as an option in sentencing, often that inhibits them from being able to even be part of a guilty verdict as to capital murder, first-degree murder, felony murder, because they don't want to sentence the person to death. And in Liddell Lee's case, I think we saw in his first trial, which ended in a mistrial, one of his jurors would not even deliberate because she didn't want to convict him of first-degree murder or capital murder because he faced the death penalty. So that is the reasoning behind often they can't even convict when the death penalty is on the table. So that is why. And they also found that Guidry could not show that the state suppressed fingerprint evidence. He failed to establish cause for defaulting his Brady claim. That he could not show cause to excuse procedural default because the state habeas counsel was not ineffective for failing to raise a meritless ineffective assistance of trial counsel claim. So the COA was denied. Guidry filed a petition for rehearing. The rehearing was denied without poll, but on June 23rd, 2021, the Fifth Circuit withdrew that April 21st opinion and substituted it with a published opinion, which held appellant's request for certificate of appealability was denied because appellant's attempted extension of Harrison precluded relief under the Anti-Terrorism and Effective Death Penalty Act. That's AEDPA. Because the doctor was a private defense expert and did not conduct a psychological examination, appellant could not show that jurists of reason would debate that the state court decision did not violate clearly established federal law as determined by the Supreme Court. The state's peremptory strike of a potential black juror did not violate appellant's right to a fair and impartial jury under Batson because although membership in the NAACP could be so intertwined with race to render it inherently discriminatory, the court found the reason did not show that the state was motivated in substantial part by discriminatory intent. And the certificate of appealability was denied. Guidry filed a petition with the U.S. Supreme Court on November 18, 2021. And the issues presented, because we're in an era where full petitions and full oppositions and full documents and appendices are available online with the U.S. Supreme Court, which is a wonderful thing. Now we can have more information about the petitions being filed. Yay! Guidry raised a 7 questions presented. First was whether the Fifth Circuit improperly addressed the merits of the habeas claims rather than determining whether jurists of reasons could disagree with the district court's resolution of Guidry's constitutional claims, or that jurists could conclude the issues presented are adequate to deserve encouragement to proceed further. That's the basis for a certificate of appealability. Whether the state's preemptory strike of a black juror because he belonged to the NAACP constituted unconstitutional race discrimination under Batson versus Kentucky, where the state failed to offer any credible race-neutral explanation for the strike, which isn't true because they offered multiple race-neutral explanations for the strike, and the NAACP was one among many. Whether Guidry's procedural default of appellate counsel's deficient performance is excused, where Texas law required him to file his habeas petition before his direct appeal was concluded. Whether the state may excuse its failure to disclose exculpatory evidence in violation of Brady versus Maryland by asserting with no evidence and contrary to this court and other circuits holdings that it had an open file policy, and without establishing that the exculpatory evidence was present in any files available to defense counsel. Whether trial counsel was ineffective when during a retrial they failed to object to testimony on the basis that in an earlier habeas case, the Fifth Circuit held that very testimony violated the Confrontation Clause. This is Gipp's testimony. Whether ineffective assistance of trial counsel in a first trial that prejudiced the defendant in the second trial violated the Sixth Amendment, and that was Nunnery's failure to adequately counter Bassinger's testimony about Guidry's admission to shooting Farah. And then finally, whether Guidry's procedural default is excused because habeas counsel failed to investigate and present exculpatory fingerprint and ballistic evidence supporting actual innocence. And Guidry's claim of actual innocence was like very tenuous because a lot of it was based on a cuckoo allegations of Fratta. Also, on the Brady violations alleged, there are 2 parts to Brady. First is that it was that the evidence was even suppressed by the state, and subsequent decisions of the U.S. Supreme Court have kind of narrowed, expanded, focused Brady on different ways and different things. It used to be it had to be knowing, and now they've changed it where it can either be knowing or it can be inadvertent, but it's still, suppression and it's still wrong. But the evidence has to be material, and the evidence has to be capable of changing the outcome. So a fingerprint on Podorski's car, a fingerprint rather, that Guidry can't show or prove was actually on Farah's car, because the reports he was relying on didn't say what vehicle the fingerprints were even found on. They were just found on a vehicle that was examined during the investigation. That's not material. And it would not have changed the outcome if they tried to present it as having been found on Farah's car and then having it turn out that it was found on a vehicle that wasn't in that garage that night. So that's, people hear Brady and people hear suppressed and they think, oh my gosh, automatic reversal. But it has to be something that would have changed the outcome. And ballistic evidence that is inconclusive is not exculpatory. Fingerprint evidence that you can't prove the fingerprint was found on the victim's vehicle is not exculpatory.
Right. Exactly.
Confessions that are not supported by eyewitnesses who describe a short black male with a big head. And as I said at the beginning of the show, that fits Guidry to a T. Look at his pictures online. He's got a big head. That would not change the outcome of his trial. The court held a conference on February 25th, 2022, and they issued an order denying the petition on February 28th, 2022. And so that is the end of, Guidry's state and federal post-conviction relief. Excuse me. I got the hiccups now. So I apologize in advance. And as we know, Fratta was executed January 10th, 2023. Kim Ogg, the district attorney in Harris County, has not moved for execution dates for either Prystash or Guidry, even though they
And
have
probably
each
never
exhausted
will.
their state and federal post-conviction
She's not the most
remedy.
pro-prosecution DA in the world.
I was somewhat surprised that she had requested Fratta's date. It's odd, though, that she requested Fratta's date and then she requested dates for 2 or 3 other individuals out of Harris County, but not Guidry and Prystash. I would think that if you're requesting Fratta, go ahead and request Guidry and Prystash at the same time, because she did that after Guidry's claims and Prystash's claims finished before Guidry and Fratta. So he's been eligible for a while, but so's Linda Carty, but she hasn't asked for Linda Carty either. So that remains to be seen whether she will ask for that or let them linger until a new district attorney comes in. And that is, I think, Howard Guidry. Or I think that should conclude Howard Guidry. Any questions? Any thoughts? Any
No, man, I just think, like I
observations?
said, I think this is an interesting case. I mean, as like I said before, I really love my kids and can't live without them, and the best way to show that is by killing their mother is just such a weird,
Well,
just odd thing. I mean, not that like to your point, don't necessarily believe it, but
as I've said, that
just,
wasn't really
yeah,
Fratta loves Fratta,
yeah.
and Fratta didn't want to lose. And Fratta thought, if I get rid of Farah, nobody can tie it to me. I'll get away scot-free and I'll be sitting on top and I'll have all this money and everything, will go my way.
And I mean, I guess in
And thank God
reality,
he was wrong.
yeah, I mean, he almost did. I mean,
Mhm.
it was, surprisingly, he did seem like he almost got away with it if
Yeah.
hadn't been
And,
for Gip.
as we looked at the 3 parts and each of them had different levels of participation, but I don't think any one was any less culpable than another. I think they were each fully culpable for Farah's death.
Yeah,
Fratta wanted it to happen.
absolutely.
Prystash agreed to assist, and Guidry caused it to happen.
Yeah. Well, yeah, I mean, Fratta really, I mean, without him, he's the one that ultimately, without him, there's no murder. I mean, yeah, you could say that for Guidry, but probably find somebody else to do it. But yeah, without him doing it. And, in some ways, I mean, I don't excuse Guidry, but I mean, I almost hold Fratta in more contempt than him because, Guidry's just a messed up kid with a lot of problems who, like you said, would do anything for money and drugs. Doesn't excuse him, but relative to Fratta, who is killing his kid's mom and his former wife just out of selfish, reasons I mean, I actually hold him in worse contempt.
I think so. And in my level or my personal opinion, the person who arranges the murder, even if they don't lift a finger, they are the one who is the most culpable for it happening, because they wanted it to happen and they engineered it to some degree. Because Fratta, Guidry and Prystash could not have killed Farah without knowing where she lived, without knowing her knowing her routine, knowing her schedule, and knowing that the children would not be with her and would be with Fratta. It could not have happened. So yeah, I think Fratta is the more culpable, and that's probably why Og requested his date first. Because you can't really debate his culpability too much. Even though he claims, he didn't do it and he didn't have anything to do with it, and Prystash and Gipp were framing him. And I do want to point out one other thing. In the last Fifth Circuit opinion, they did have a factual error. If anybody ultimately reads that June 23rd opinion, the last Fifth Circuit opinion, they said the gun belonged to Farah, but it didn't. It never belonged to Farah. It was purchased by Fratta. Farah had taken it and given it to her father to hold, probably because she was afraid of what Fratta might do with it. And Lex ended up giving it back to Fratta the summer before the murder. So it was not Farah's gun. It was not in her possession. And it really never was in her possession, because she took it and gave it to her father, and her father gave it back to Fratta. Fratta's tried to claim that it was her gun for protection, but that's a lie. How do you know Robert Fratta was lying? His lips were moving.
Exactly.
So,
Yeah,
all right.
Yeah,
well,
he looks creepy.
Yeah, he was a creepy guy. He was creepy. And a sick puppy. And he's probably in a hot place right now, getting poked with pitchforks and doing all kind of things he doesn't like, or having things he doesn't like done to him. So, or if, as in the TV series Lucifer, if it's his worst mistake, he's reliving Farah's murder over and over again. Because I think that would be probably his worst mistake.
Yeah, absolutely.
Or reliving the plotting of Farah's murder over and over again.
Yeah, seriously.
So, and that's about the limit of my metaphysical beliefs. So, all right, well, I think that wraps it up. I do want to make one comment. I have heard and seen that the Attorney General for Oklahoma, Gentner Drummond, who is an absolute turd, has now adopted the side of the devils and sought that Richard Glossop's conviction be vacated based on the BS in the Reed Smith report, based on the non-exculpatory information gathered by Reed Smith, and based on the false premise that Justin Sneed was dishonest about his reasons for being prescribed lithium while in jail awaiting trial. And I've heard that. I don't know when I'll be able to deal with that, because much like Adnan Syed's conviction being vacated, it is a topic that makes me very upset and very angry and very ill, but I will hopefully be able to deal with it sometime in the next few weeks. I may endeavor to wait until after the Oklahoma Court of Criminal Appeals has weighed in, because ultimately the determination of whether his conviction is vacated or not is with them. But I hope that anybody who put Gentner Drummond into office as the Oklahoma Attorney General, I hope that he suffers consequences, because he is not serving the citizens of the state of Oklahoma. He is potentially exposing those citizens to a multi-million-dollar verdict in favor of a piece of crap named Richard Glossop, who got a 19-year-old drug addict to kill a family man with 7 children, one of whom, at 5 years old, begged her daddy not to go to Oklahoma City that night or that day. And that, for right now, that's all I can really say. And I know you're sitting there thinking, yeah, Lisa, tell us how you really feel.
You never had a problem with that.
No, I sure don't. I am not as my grandmother used to say, I am not one to suffer in silence. So, all right, well, let's wrap this up. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Join us in 2 weeks, thereabouts, for episode 5, State of North Carolina versus Molly Martins Corbett and Thomas Michael Martins. Martins, a former FBI agent, and his daughter Molly are awaiting retrial for murder in North Carolina. In the early morning hours of August 2nd, 2015, Molly's husband, Jason Corbett, was beaten to death with a bat wielded by Martins. Their self-defense claims were quickly rejected by investigators, who charged the pair with second-degree murder. We'll talk about the evidence against Corbett and Martins, their initial trial and state appellate claims, which resulted in the grant of their new trial requests. Until then, have a great 2 weeks and stay safe.